The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning. Mr. Citron, you ready?
Yep. Thank you, Your Honor. May it please the court. Question for the court is whether Atrium Health, a multi-state healthcare enterprise generating $11 billion a year in revenue, is a local government entitled to complete immunity from antitrust damages. There are lots of reasons why it is not, but we think three are especially strong. First, to fall under the statute, a special function governmental unit must have been, quote, established by state law in one or more states. Atrium, however, was not established in the laws of several states where it operates, including Georgia and South Carolina. Congress could not have intended to allow a single state, like North Carolina, to authorize the creation of corporations that could then do business across the nation, free from any need to pay back citizens of other states that they injure. Instead, when, as here, an entity operates in multiple states, it must have been, quote, established by state law in one or more states, the states where it operates. There are essentially two options under the statute. You could be established by state law in one state, or you could be established by state law in more than one state, but you can't be established under the state law of a state and then operate wherever you want. Second, Atrium has limitations on its powers that just belie its claim to governmental status. We think the most important one is that if Atrium is held liable for antitrust damages, it has no way to pass that liability on to taxpayers. The LGAA was enacted precisely to ensure that antitrust liability would not bankrupt local governments. And you can see that actually in the structure of the statute, although it's also all over the legislative history, right? It doesn't prevent antitrust liability. It only prevents the payment of any kind of money, not just damages, but also attorney's fees or costs. It's all about protecting the public fisc. And third, and I think this is also very important, the statute actually, the LGAA has a section that is devoted to things like what Atrium claims to be in its brief, which is an instrumentality of, or an agent of Charlotte. Now, query whether that's true. I'm not sure why an agent of Charlotte is providing healthcare services in Georgia, but even if it is, Section 36 says that a person can also claim antitrust damage immunity under the LGAA if their actions were directed by a municipal government. And the reason that we're not arguing under that section is that there's no argument that Atrium's anti-steering provisions are directed by the local government. But that is how something that is an instrumentality of or connected to or supervised by a municipal government might be able to claim immunity. It does not thereby become a local government that is per se immune from damages under sections 34 and 35. I'm inclined to say that if there are no questions, I don't have anything else to begin with.
Mr. Citron, I have a question.
Sure.
From reviewing your materials, you at least in the briefs, you hadn't really talked about it quite as much today, but that you find significant the language in B that other special function government follows school district and sanitary district, and that under the the rule of statutory construction that you cite to, the general should be interpreted by the specific. Is it clear or certain that a school district or a sanitary district would necessarily possess the powers you say must exist for a special function governmental unit? I say that because these entities are creatures of state laws, and state laws aren't all the same. So I'm interested in how you conclude that a school district and a sanitary district necessarily have the power to tax, have the power to issue general obligation bonds, and have the power to exercise eminent domain, independent of, another state agency?
Sure, it's a great question. And I want to answer both with something specific and then a more general discussion, which I hope will be responsive to your point about how state law varies. The specific point is, you might take a look at the statute in North Carolina that creates sanitary districts. It's section 130A-55. And I'll just point out that the third power listed is a general power to raise taxes. The fourth power listed is the unrestricted right of eminent domain to acquire property by condemnation. There's a further taxing power that's in section 15. And then section 16 is something very close to an ordinary police power. It's a power to, quote, make rules for the promotion and protection of the public health. So sanitary districts are, very recognizably like governments in a way that something like Atrium is not. Now, your more general question is about how we know that, like, in general, I think a sanitary district or school district would be like that. And, what this calls to mind is, I don't know if the court has a lot of experience with ACCA, the Armed Career Criminal Act, which is another federal statute that tries to incorporate a bunch of state law crimes that will all vary. And the way that the Supreme Court has taught us to understand statutes like that is to look to what the ordinary version of burglary would be, or the ordinary version of, I can't remember what the other crimes are right now. So, I think what you would ask is whether a typical school district or an ordinary sanitary district would have these kinds of powers associated with them, not whether every sanitary district or school district in the nation has it. And I think it's pretty clear that an ordinary school district or ordinary sanitary district would have at least one of the characteristics that we described. We're not saying they're all necessary. Really, any of them might be good enough. And certainly school districts, right? They must have some recourse to the taxpayers because they provide education for free, right? So unless they have some access to revenue, they won't be able to provide their function. And sanitary districts, like I said, they not only usually have taxing authority and other authorities, they often have something like the police power because they have to govern how residents will dispose of their trash and how they have to maintain their property. And they also often have to condemn areas for sewer lines and things like that. In North Carolina, sanitary districts can even create things like fire departments and raise taxes to pay for them. So they're pretty different.
May I ask you a question? I'll admit that this is really not a hypothetical, so be careful. It's a counterfactual, really. So with that proviso, be careful.
Judge Gregory, I apologize.
Can you hear me now?
You started clipping, so I missed the whole beginning of what you said.
Okay, well, I'm going to ask you a counterfactual. It's really not a hypothetical, so just beware of that. In 1943, when this was formed in its nascent years, if it had never grown geographically beyond the boundaries of the standard metropolitan district area, or anywhere near the amount of money, the net revenues, would there be any problems with this falling under the Local Government Antitrust Act?
It's an extremely difficult counterfactual to answer, in part because the Local Government Antitrust Act has passed 40 years later, but I would say—
That's what I'm saying, because I want to see where, if anything, did it, in its formation, in terms of what the original powers it had, assumed that the act did exist, would that be any problem, or is it merely solely geographical and fiscal growth that's the problem?
So I think it would still be a serious issue that when it was created as an alternative to a municipal hospital, which would have recourse to taxpayers, and instead is set up as something that has no recourse to taxpayers. That's a very important clue that it may not be what the Local Government Antitrust Act considers to be a local government. And then the fact that it also lacks eminent domain power is a further indication. But the fact that it is closely circumscribed under original law to the boundaries of the municipality that creates it does make it much closer a case. So I'm not sure I could commit to the idea that it would be, although of course it's not important for this case. But I will say it's much closer under the law as it originally existed in 1943, whether or not something that was essentially circumscribed to Charlotte or 10 miles outside Charlotte would be a local government in a way that something with the power to operate in Alaska is not. Does that answer the question? I apologize if I'm not trying to weasel out of the hypothetical. It's a hard question.
Judge Keenan has a question.
Okay, Mr. Citron, I'd like you to address the D. Cesar case, the North Carolina Supreme Court case, because I realize it was decided under state antitrust law, but it seems like a lot of its reasoning might be pertinent here. So could you please tell us why, in your view, it is or is not persuasive?
Yeah, I think it's persuasive on its own terms. It's just very important to recognize that what it's mostly answering is the question whether a quasi-municipal corporation is a corporation for purposes of the state's antitrust laws. And it's not actually answering the federal law question that we care about, which is whether or not it counts as what Congress had in mind as a local government at the time. And this is really important in part because of the federalism aspects of reading the LGAA the way that the defendants have asked you to read it. You know, if it was just a question of whether you were stood up by a municipal government for a public purpose, you would create a situation where the state of North Carolina, if it wanted to, could immunize firms founded in North Carolina for their antitrust damages that they cause in other states and around the nation. And that has to be a federal question, and it has to be focused on what Congress cared about, because otherwise you'd permit state legislators, state courts, even municipal entities to attach a label to something without giving it any actual governmental powers over its people or anything like that, and thereby immunize it for its out-of-state operations. I'll just point out also that for federal law purposes, it would be very weird to think that this was a local government, in part because the activity that it was engaged in here was so bad that it was not sued just by the federal government, but also by the state of North Carolina for harming the people who use the health system. So, you know, it is odd to think of a local government that isn't responsive to the state and isn't responsive to its local residents, but has to be sued, you know, in order to start complying with federal antitrust laws.
Right, but the injunctive relief is still available.
That's right. The injunctive relief is available, but I think the point is they had to go bring a lawsuit. They couldn't vote, you know, to stop doing things that way. The state couldn't direct it to stop doing things that way. Okay. It was acting like a firm would act and not like a government would act.
Okay, well, let me just ask you a last follow-up, and this is on page 35, going over to 36 of the slip opinion of the Carolina case, where the courts really relies on the fact that the hospital authority has the power to acquire real property, to issue revenue bonds. It's subject to annual audits, and court seems to focus on the kind of the day-to-day functioning and the powers of this entity, and why wouldn't those be relevant in the federal context? I understand they're two different sources of law, but why aren't those concepts, why don't they correlate to what we're doing here?
Yeah, so one really important point is that if we're talking about the way that it's subject to audit or the public records law, stuff like that, things that aren't the powers of the corporation, but the powers of the state and municipality over it, right? Mm-hmm. Those are captured by the federal law through Section 36. The statute has a section that's about control by local government, and it has a condition that the action has to be directed by the municipality. And it's reading that condition out of the statute, right, in a way that does not respect Congress's text to say that you don't have to be directed by because it has these oversight powers, right? That's backwards. You all clipped for a second there. Could you hear that?
We heard you. You just froze video.
Okay. Well, as long as you heard me, I think that's the important part. The other part of my answer to Judge Keenan's question is that the powers that are described there, the power to acquire property or the power to raise revenue on your own, to issue bonds on the promise of your own revenue, those are powers that are shared by private corporations and that Congress would have thought of as non-governmental powers, right? If you think of an ordinary national corporation like Bank of America, it can acquire real property and it can issue bonds on the promise of its own revenue. So when Congress has something in mind, it's not powers like that. It's powers that you would associate ordinarily with government, the power to have recourse to taxpayers if you incur liabilities, the power to take property on your own say-so from private citizens, or the police power, the power to actually issue regulations and control people's lives. So, and I just point out that the very last sentence of that paragraph, it does say, we are satisfied that the hospital authority is a quasi-municipal corporation rather than a for-profit corporation coming in within the purview of NCGS section 7516. So the tension that state law cares about is between the hospital, the quasi-municipal corporation, and a for-profit firm, but federal antitrust law has rejected that. There is no need to be a for-profit firm to be subject to antitrust law. You can be a non-for-profit firm. And that's because, of the lavish salaries that, frankly, the executives at Atrium Health will sometimes earn from, growing their empire. I'd like to reserve the balance of my time if I can.
All right, thank you, Mr. Citron. Mr. Cooney?
Thank you, Your Honor. Let me begin by saying what the plaintiff is asking this court to do is to create an area of federal common law that hasn't existed since the passage of the LGAA. He's asking the court to dictate federal standards for what a special function governmental unit established by the state is. And in doing so, respectfully, he's made a number of statements that are simply incorrect based on the record. First of all, the hospital authority has the power of eminent domain and has the power of eminent domain as a public condemnor, not as a private condemnor. It's lumped in with all the other public condemnors. And in fact, the hospital authority's property cannot be taken by eminent domain without its consent. In addition, the hospital authority has such additional powers such as closing streets or maintaining parks or doing things that are associated with the public health function. So when you read through that long list of powers that are given to the hospital authority, you see a lot of powers that do in fact look like those police powers he's talking about. Now, Judge Keenan, I think you asked the right question about the impact of the Caesar, because this case turns on 13 words in the Local Government Antitrust Act. And those 13 words are whether the hospital authority is a special function governmental unit established by state law in one or more states. So we begin with the fact that whether it's a special function governmental unit is established by state law. It's not a matter of federal law. You look to state law. And when you look to page 37 of the DeCesar opinion, shortly after the section you referred to, Judge Keenan, about the middle of the page, the court finds in several places that the hospital authority is a quasi-municipal corporation. And then Justice Irvin describes what a quasi-municipal corporation is under North Carolina law. He says quasi-municipal corporations are agencies which have been specifically created by the General Assembly by means of a legislative delegation of authority to carry out the governmental purpose of providing a service for the benefit of the public, which the legislature is not as well positioned to carry out itself. In this sense, quasi-municipal corporations are an extension of the government that have been created to more efficiently and effectively manage the provision of necessary services to the public. Although quasi-municipal corporations are not subject to all the requirements applicable to other governmental entities, it is clear that their essential function is at its core the governmental provision of services. I can't think of a clearer expression by a state that this is a special function unit of government than that description. Judge Gregory, I'm getting some feedback and I apologize. Judge Gregory,
Let's qualify him as a question for you.
Oh, I'm sorry, Your Honor.
That's okay, counsel. Can you hear me okay?
I can, sir.
Okay. I think I understand your position about how your client qualifies as a special function government unit. My question is there, in your view, if it was created as such and maybe even remains, as such under state law, is there any point in its growth that might take it out of a local government definition? Is there anything that, I mean, here we're in 3 states allegedly, and if you're in 50 states, if you're international, is there any point at which, even if you were qualified and remain qualified under state law, that you lose that designation? Or is it your position that as long as it makes that and we go do whatever, we're still protected by something under the title local government?
So let me respond to that in a couple of ways. First of all, we actually have an example of that in the Capital Freight case, in which the government of Puerto Rico established a quasi-municipal agency that paired up with a private agency to basically run all the cargo shipping between Puerto Rico and all the states of the Union and internationally. So by definition, that company operated in all 50 states, and it was found to be a special purpose unit of government. Now, specifically on this case, what I'd like to suggest is the plaintiff is presenting you an issue that you don't need to decide yet. Now, the hospital authority is alleged to have market power in only one state, North Carolina. Any anti-competitive actions that have taken place were alleged to have taken place only in one place, North Carolina. These contracts were entered only in one place, in North Carolina, and the plaintiff received all his treatment in North Carolina. If at some point in the future, the hospital authority were to have, say, market power in Georgia, Your Honor, and was sued in Georgia for acts that it took in Georgia, I think that's a different question. Now, you may reach that answer, that because it's been established in North Carolina, that might carry over, but you wouldn't necessarily need to reach that answer because it's not operating as a hospital authority in Georgia or in South Carolina. It only operates as a hospital authority in North Carolina. So I think the plaintiff, in an attempt to get you to embrace a federal common law here, is asking you to decide a question that's not before the court. What's before the court is on this complaint, on these allegations of North Carolina contracts, North Carolina antitrust injury, North Carolina special function unit of government. Does the hospital authority qualify? And that is yes, but that doesn't necessarily dictate what may happen in the future should the hospital authority have market power in South Carolina or in Georgia. The other thing, Judge, that I would point out is the LGAA itself seems to contemplate that a special function unit of government would do business in more than one state because it says that. And we know the Massachusetts Port Authority and other port authorities and regional planning authorities all operate across state lines. And of course, as you well know, Charlotte and the Charlotte Hospital Authority operates right on the state line with South Carolina. A lot of patients come in from South Carolina. One of the powers that was given to the hospital authority by the General Assembly was the ability to provide healthcare services outside the state of North Carolina. So it's well within its function to do so and needs to do so to treat everyone who comes. The hospital authority doesn't ask for an ID when you show up at the door, it treats you. And it needs to be able to provide that treatment across state lines. That was contemplated by Congress. So respectfully, I think he's trying to get you to decide something that's not before you. Finally, all the references to Georgia, I'd point out that none of those have anything to do with this lawsuit in this sense. It's undisputed that as a result of a settlement with the United States government, these anti-steering provisions were stopped being enforced in November of 2018. The transaction into Georgia didn't occur until January of 2019. It wasn't operating in Georgia during the time period of the complaint. And as the Terabishi case makes clear, which they rely on so heavily, it's the time period of the complaint that dictates what the entity is. In Terabishi, you might recall, the public trust hospital there was excluded from the definition of a political subdivision for a 2-year period from 1985 to 1987. They were later added to that definition. But the court said the fact that they were later added can't affect the complaint because the complaint was for a specific period of time, even though once they were added, they would have reached a different result in Terabishi. We have claims here in 2016 about contracts that were entered into before 2016 at a time when the hospital authority was not operating in Georgia, and there's no allegation in the complaint it was operating in Georgia. So respectfully, that really is a red herring. Now, Judge Gregory, I would like to address your question about size, because you indicated that can a sub-state entity become a certain size and lose that character? And of course, the plaintiff compares the size of the hospital authority to the size of the city of Charlotte. But what they don't do is compare it to the size of the counterparties. So the hospital authority has to negotiate with 4 private insurers. Those 4 private insurers control 85% of the private insurance market. Every one of those insurers has revenues or assets that dwarf the hospital authority. The reason the hospital authority needs size is so that it can hope to achieve somewhat of a level playing field with insurers, and the state of North Carolina understood that. Because if you're a small rural hospital, you can't negotiate with Blue Cross Blue Shield of North Carolina and get a reasonable rate, let alone Cigna or Aetna or United Healthcare, and that's why they're closing all over the state. You need enough size to be able to act as a counterparty for that. And size is important too, because it enables you to do things. Charlotte is the largest metropolitan area between Washington and Atlanta. If it wasn't for the hospital authority, Charlotte wouldn't have a level 1 trauma center, it wouldn't have a solid organ transplant, it wouldn't have the advanced cancer services, all of which are made possible because you've achieved a certain size, all of which go to the benefit of the citizens and residents of North Carolina. So if you start drawing arbitrary lines that how big is too big, and if it gets too big, you're going to, particularly in healthcare, you're going to deprive the citizens of a lot of opportunity to get the kind of quality healthcare that the largest metropolitan area within 300 miles is entitled to. Mr. Citron keeps making the point that, well, taxpayers won't have to pay for any judgment he gets. And that's right, but up to a point. It's right in the sense that, yes, the city of Charlotte is not going to have to write a check for any judgment that he may obtain. But it's wrong in the sense that any judgment he obtains is going to be taken out of public assets, because the assets held by the hospital authority are public assets. They revert back to the county and the city when the hospital authority is either goes out of business, ceases to do business, can't do business, or the state of North Carolina decides to undo its creation. But these are public assets. This is a public body. And so any judgment is going to be taken out of those public assets. And I don't believe Congress intended the thing to be so narrow that as long as taxpayers are not having to pay, then it's not a local government, special function unit of local government. Yes, Your Honor.
Mr. Cooney, you had said earlier that making the point that the hospital authority only operates as a hospital authority in North Carolina. It doesn't operate as such in Georgia. How would you characterize the nature of its operation in Georgia then? If it's not a hospital authority, what is it doing there?
Well, structurally, let me answer that in two parts. So structurally, from a matter of legal formalities, the hospital in Georgia, which it didn't get until 2019, owns its own assets and is a part of a limited liability corporation. The hospital authority is the sole member of the limited liability corporation. But the hospital authority does not own those assets directly. Those assets remain the property in Georgia. And the Georgia Attorney General had to approve the transaction. Let me go back to the implicit question you made about what's it doing in Georgia. I think to put a finer point on it, the question may be, how does operating a hospital in Georgia help the citizens and residents of North Carolina and Charlotte? If I think
and to follow up on that as part of your answer, because see, if it can't exercise its quasi-governmental powers in Georgia, it can't exercise the power of eminent domain, it can't issue Georgia revenue bonds, then what is the nature of its operation?
Well, as I said, the nature of its operation is more in terms of a management function, and this gets to how it benefits North Carolinians, because healthcare in general, but hospitals in particular, have very high costs. And so what you want to do is you'd like to spread those costs out among as many people as possible to lower the operating costs, and that way you lower the prices. So for example, for Navicent, they don't need a freestanding legal department. There's a shared services legal department. There's shared services accounting. For purchasing in particular, once you get to a certain size, you can demand larger discounts on hospital beds, on PPE, on surgical suites, on x-ray machines, on the things that make a healthcare system function. So the larger that system can become, the more the more of a discount you can get on the operating side, which lowers your cost of operation and therefore can lower the prices overall for all your patients, including those in North Carolina. But Judge Keenan, I think you're bringing up an excellent point, and it goes to what I started off by saying. You don't have before you a claim that in Georgia, the hospital authority entered into contracts that violate the antitrust laws as a result of its market power. And if you get that claim someday, then I think your point is well taken, because I think the court would be willing to, it makes perfect sense to demand that if you seek an exemption from antitrust damages for actions that take place in a given state, you operate as a special function unit of government in that state. But that's not this case. And I think it's important to understand that it's not this case. And I think it's also important to understand that the courts have routinely recognized states can, or that these special function governmental units can function in more than one state, and Congress anticipated that. It meant to include regional planning commissions, regional environmental commissions, regional transport entities. The Charlotte Douglas Airport Authority, I think, is a classic example of that. None of those authorities meet their definition of a government. And I think that's the other flaw in their logic. They keep wanting to refer to the Charlotte-Mecklenburg Hospital Authority as a government so that people say, oh, well, of course it's not a government. Congress was more sophisticated than that in the statute. Congress realized there were two kinds of entities to protect. One was a general purpose governmental entity. And those general purpose governmental entities in subsection 1A are cities, counties, towns, parishes, what we would think is government writ large. Those are general purpose government entities. But Congress also understood that since at least McCulloch against Maryland, we've had quasi-municipal corporations that the states have created and stood up and delegated functions to in order to provide public benefits for public purposes that are not general governmental entities. That's what the hospital authority is. So to say, well, how is it like a government, is asking the wrong question. It's going to lead you to the wrong answer.
Mr. Cooney, you said that we're not at the question of whether or not Georgia's operations somehow may have a different result in terms of litigation or liability. But what do we do with the word local? Local is really not defined by the amount of money you make. Local is local. And because, for example, if that's the case, New York City is huge. I mean, it must have an operating budget of several billion, triple digit billions. But it still could be local if it's only contained in the 5 boroughs. So it's not a matter of money. But when you're talking about an operation like you have here, Atrium, is it in a sense no longer local, notwithstanding not the metric of money, but just the metric of footprint? And that aspect of it is no longer local because it's far flung that. So it's not a question of whether or not this question touches Georgia. Question is it morphed to no longer local? Would you respond to that?
Well, yes, Your Honor. I think that's an excellent question. Congress anticipated that these special function governmental units would operate in more than one state. And Atrium, by virtue just of physically where it is, has to operate North and South Carolina. It just has to.
Well, perhaps that was because they were anticipating perhaps 2 states may get together and somehow do some kind of joint venturing together, but it would still be local as to those entities. So that's still. Go ahead.
Yes, but Congress did not limit it to that. They didn't say states have to get together. And there's certainly nothing in the legislative history that indicates you have to be in each state a special function purpose of government. What Congress specifically considered, and what the courts have said, for instance, I go back to Zapata and Capital Freight, where again, you've got this Puerto Rican entity that effectively operates in all 50 states. And there's no way you could describe that as local. But the courts had no problem saying it still meets the requirement of a special functional government unit established by a state, in that case, Puerto Rico. So I think you would be engaging in a reading that no other court has engaged in to say local controls what's established by a state and local imposes some border restriction at some point. But what's the difference between the Massachusetts Port Authority operating among 4 or 5 states because of where it's regionally located, and the Hospital Authority having to operate in North Carolina and South Carolina because many of its patients come to it from South Carolina?
Well, most of those authorities, they have signatories by each state that participate in those authorities?
Well, not necessarily. I mean, most authorities have for instance, there's a New York Port Authority, there's a New Jersey Port Authority. Now they cooperate with each other, but New Jersey is not a member of the New York Port Authority any more than New York is a member of the New Jersey Port Authority. So they certainly probably have cooperative arrangements, but the port authorities themselves are established in the state by the state as a special function unit of government. Same with regional planning commissions and environmental planning commissions. As a legal form, we have to go back to what the statute says. Has this been established by at least one state as a special function governmental unit? And I apologize because I've run over my time, sir.
No. You were answering questions. Any further questions of Mr. Cooney? Yes. All right. Thank you, Mr. Cooney. Mr. Citron, you have some time reserved.
You're on mute.
Okay, here we go. Thank you. I'd like to start with the very last point that Mr. Cooney was making, because I think it's really important that he did not give you the statutory text. He gave you a paraphrase of it, which is not accurate. It does not say established by state law in at least one state. It says established by state law in one or more states. And what that is contemplating is an entity that might be established by state law in one state, or it might be established by state law in more than one state, but not an entity that is established by state law in a state and then operates wherever it wants to. That's a corporation, a firm, right? Bank of America can be incorporated under state law in Delaware and then provide banking services wherever it wants to. And that is a core textual difference. It is important to attend to the words Congress actually used and not give them a gloss like at least one state or something like that. If that's what Congress had meant, it didn't even have to say one or more states. It could have just stopped at established by state law. And then Mr. Cooney's argument would hold. But that's not what it said. It clearly contemplated things like WMATA in Washington, D.C. and Maryland and Virginia, or the New York, New Jersey Port Authority, which is one entity. It has a single CEO, and not things like Atrium that are just operating wherever they want to. And
so
at this point,
Mr. Citron, if I could kind of stop you there, because I mean, as I read it, I don't think it reads so clearly in your favor or so clearly in Mr. Cooney's favor. I'm not sure exactly what that means, to be honest with you. And which kind of, I guess, brings me to this question. And the fact that it says in one or more states, you're right. It may be something like a joint operation, like a local, a transit authority or something like that. But it seems to me that it doesn't exclude an entity operating in one or more states. And I guess my concern is, I feel like, I wonder whether you're asking us to impose limitations on this statute that are really Congress's job. I mean, it seems like in the first instance, you're asking us to impose some kind of hierarchy of governmental unit, one that has, certain powers that at least isn't expressly in the text. I mean, I understand how you get there. And now you're asking us to impose some limitation on operations. It may make a lot of sense, by the way. I'm not suggesting it's not illogical or bad policy, but I don't see it in the text. And so I'm wondering whether you're asking us to essentially do a modification of the statute.
Certainly not. I do think that the reading that I've offered of established by under state law in one or more states is the better one, but put that aside. The word local government is in the statute. Mr. Cooney said there's only 13 words that matter. That's not right. Okay, local government matters, and the Supreme Court has told us this over and over again. We cite Leocal in our brief, but the Bond case would be another great one to look to, right? That was a case where the underlying statute was about chemical weapons, right? And the definition was something like any toxic chemical. And so someone was prosecuted for using a toxic chemical because it met the definition. And the Supreme Court was like, but no one would describe household bleach as a chemical weapon, even though it meets the definition. This is that case. It is impossible to describe Atrium as a local government. And that's important because those are the words Congress used.
Okay, well, Mr. Citron, then to follow up on Judge Quattlebaum's question, and it's something I do pretty much every time I listen to lawyers' arguments. I try to figure out, okay, how we're going to write this opinion.
Yep.
We're going to write it if we agree with you. How big is too big, and how do you write that in the context of a court decision as opposed to, as Judge Quattlebaum's saying, legislative amendments?
Yeah, so I think the easiest way is just to note that unlike any other local government I've ever seen, Atrium has the power to operate in any state where it wants to. And that power was granted in 2015. I'm not saying it stopped being local because it built or bought hospitals in Georgia. It was already had hospitals in South Carolina long before that. I'm saying it's not local because the North Carolina legislature decided to allow it to operate wherever it wants to, which is not something you do with a local government. Right? Charlotte doesn't, sell sandwiches in Alaska or whatever. It provides services to local residents. It's providing its services not to local residents in non-contiguous areas of states on the other side of other states. Right? That's not local within any meaning of the word, and that's all you'd have to say to decide it. The other point we've made is not that one particular power, the taxing power, the eminent domain power, is necessary It's just that you'd have to have at least one of them, but none of the things that are typical only of governments seem to be true of Atrium. So that's the other important point that I would make. If I were trying to craft the opinion that way. But I think local does all the work. At the time that this statute, that 75 years ago, when this was created, it was local. It was limited by statute to operating within the municipal boundaries or within 10 miles of it. Now it's not local, and that is by a change created by the legislature in 1993 to allow it to operate anywhere in the state by making an agreement with a hospital there, and in 2015 by empowering it to operate all over the nation. And that was a choice that they made to make it a non-local entity. And that suffices, I think, to decide the case. I just want to flag one other point, which is about eminent domain. We have been trying to figure out whether or not there's any problem with our assertion that the hospital has to ask the Public Utility Commission to exercise eminent domain. We've made that really clear in our briefing below, in our briefing here, and we've gotten no response from the hospital to suggest otherwise. Now, I don't know what public condemner means. I don't know what any of those words are meant to suggest. All I know is that unlike sanitary districts and unlike local governments, the hospital authority is specifically restricted by state law from using the eminent domain power without the say-so of an actual governmental entity.
All right. No further
Thank
questions.
you.
All right.
Oh, Judge, do you have questions?
No, I didn't see
my
it.
time has expired.
Yeah.
Thank you very much.
All right, Counsel, thank you so much for your argument. We appreciate that. We would love to come down and shake your hand as our normal custom in the Fourth Circuit. In the circumstance, we can't do that, but know nonetheless that we appreciate very much your fine arguments being here today. And we just ask that you will be safe and stay well.
Thanks. It was an honor.
Hey, Counsel. All right, Mr. Allman, you may proceed.
Thank you, Your Honor. May it please the court. Good morning. I am William Allman. I represent the defendant, Fareeq Rose, in the case before the court. The key facts in this case are not in dispute. DEA agents identified 2 packages at a FedEx hub in Greensboro that were addressed to a Mr. Ronald West, who lived in Wallace, or at one point lived in Wallace, North Carolina. The first package was deemed suspicious due to the type of box, how it was taped, and the fact that it had come from Arizona, close to the Mexican border. It was opened without a warrant, even though a K9 was available, K9 unit was available. It was opened by the FedEx manager together with Detective Gordy, I believe it was, of the DEA. Narcotics were found in that box, and another box, a similar box also addressed to Ronald West, was also located. K9 sniff occurred on that box, and at that point a warrant was obtained. Narcotics were also found in that box. A controlled delivery was arranged to the residence that was indicated on the box in Wallace, North Carolina. And the defendant arrived together with another individual and was arrested after picking up the packages from the residence of Mr. West. We would submit the primary issue in this case to be addressed is the denial of my client's motion to suppress, and that the search of the second box was based on the unconstitutional search of the first box. And the key findings at the hearing and the focus of this appeal relate to the expectation of privacy in the boxes, and thus the standing to challenge the subsequent search. The fact patterns of prior cases from this court, although somewhat similar, don't clearly answer the question. The trial court in the case at bar initially referenced the Givens case, wherein there was a videotape with cocaine that was mailed to the attention of a third-party intermediary, an actual person, as opposed to an alias or fictitious person who was associated with an actual corporation. The Givens court cited Walters v. U.S. in noting, that was Justice Stevens' opinion, that authority did exist for an argument that a package addressed to a fictitious party created by a defendant did exist, but that argument was not made in that case. And so trial counsel for the defendant turned the court's attention to the case of Castellanos, wherein cocaine was found in the gas tank of a vehicle that the defendant claimed that he was planning to purchase. But in fact, he never claimed ownership of that particular vehicle at the time of the search or otherwise. And that was cited in the analysis of that opinion, which distinguishes it from our fact pattern as well. But it did not foreclose the idea that someone who utilizes a fictitious name could in fact have standing to challenge a search. In Hurley, which was cited within the brief and where privacy interest was not recognized, the fact showed that the defendant did not even know the individual who resided at the delivery address and had never used that address previously. The Seventh Circuit case of Pitts, which was cited also by the trial court, was similar to Castellanos and dealt with a fact situation, however, where a defendant had ultimately refused to accept delivery of a package and denied ownership of the particular package. There are cases out there that do support the proposition that the use of a false name does not eliminate one from asserting a Fourth Amendment claim. U.S. v. Dominique out of the Sixth Circuit, a third party rented a motel room for defendants involved in that case using a false name. There was an unlawful entry, narcotics were found, and the defendants were deemed to have standing to contest. That similar analysis was applied by the Seventh Circuit in U.S. v. Newbern. And in the Eighth Circuit, a case called U.S. v. Watson saw a home that was bought under a false name. Also, the occupant had standing in that case. The Fifth Circuit case of Villarreal, which is also cited, shows where a defendant fact pattern where a defendant paid an agent to pick up packages of shipping drums that were filled with contraband. They were shipped not under just a false name, but actually a made-up individual by the name of Roland Martin. So in the case at bar, specifically, no one ever claimed ownership of the boxes other than the defendant, Mr. Rose. No law enforcement ever disputed the fact that they belonged to Mr. Rose. He went to jail because those were his boxes.
Mr. Allman?
West. Yes, I'm sorry, Your Honor.
Excuse me for interrupting, but I wanted to get back to your concept of expectation of privacy. You know, the law carves out in terms of fictitious names a protection. There's no question. But that protection, I like to use as an example, it's David Cornwall using the fictitious name John Le Carré. In other words, there's established evidence that somebody is operating under a pen name or some other name. There's really no evidence in this record, is there, that Mr. Rose was operating under the name, that he continued to operate? It seems to me we have this isolated incident where, or instance where he puts a dead man's name on the packages, or somebody does, intending it to go to him. So where is the expectation of privacy in that kind of situation, where there really isn't any evidence in the record that Ronald West was his fictitious name? It's just that these packages were labeled Ronald West.
Yes, Your Honor, I do appreciate the question and the concern. I guess my response would be that Mr. Rose had used this alias on previous occasion. That was what would have been corroborated by Donald West had he been called to testify at the suppression hearing.
Is that in the
it
record?
Has been I'm sorry?
Is that in the record that he had used the name Ronald West on previous occasions?
I believe it is in the record that deliveries had been previously made to the same residence using the same name and picked up by the same party. So I would say that there was a pattern and practice of that particular type of transaction in play. He did place the order, as he had done before, apparently, arranged for delivery. He picked up the packages, and he went to jail for having done so. But Mr. West corroborated at trial, again, not at the suppression hearing, that he was acting basically as a nominally paid agent, had been involved in previous deliveries. He was paid to assist.
Counsel,
Yes,
can
sir.
I just follow up a little bit on your answer to that
Yes.
question?
I mean, I think there is evidence in the record that the name went on the box and, you know, he intended to go pick it up there. But
Yes, sir.
Is that really the same as alias? Isn't alias something more than that? Alias is that you go by a name. Here, it looks like the claim is because he used the name of an actual the person who has since died in order to try to get to the boxes. Yeah, I mean, that was his technique, but that seems to be different than using that as an alias. And even if you can argue that isn't the standard that we look at, you know, really one of two things. Since the motion to suppress was denied, is there evidence in the record that would, you know, support the district court's decision there, number one? And then as to the ineffective counsel claim, was it really, you know, was the decision of the trial counsel harmless? It just seems to me that, you know, accepting your argument, there's evidence to the contrary, you know, maybe even stronger evidence, but if not some evidence. And isn't that enough that we need to affirm on at least the suppression issue?
Well, thank you, Your Honor. I will try and answer it this way in terms of a bigger picture. As far as an alias goes, when we're looking at that term, I don't know if that's exactly the correct term I would use, but if I were out of town and I wanted to order something, say a package from Amazon, and I wanted to make sure it was delivered securely, I might put my neighbor's name on it and have it delivered to his house or her house. And I would argue that I still have a right of privacy. The Fourth Amendment should give me a right of privacy in that box because I paid for it. I arranged for it to be delivered. If I were a writer and I was using a pseudonym, writing under a pseudonym, and I'm receiving materials from a publisher under that name, I would like to think that I would still have a right to privacy in those contents. So I think that the demonstration of the fact that, yes, this was a drug dealer and he was utilizing this type of system for some period of time, and this particular name on previous occasions shows that he was, if you want to use the term alias, which I guess is appropriate, he didn't have an identification that says he's Ronald West. That's for sure. Ronald West was dead, but Donald West was his friend, a person he paid to assist. And Donald West was the person that it was going to. So again, as far as the ineffective assistance claim goes, it is apparent from the record that my client wanted Donald West to testify. It is also apparent that didn't happen. Would that have does that meet the Strickland standard? That's your decision. This is in the brief because it was requested to be in the brief. It was a strategic decision on the part of counsel. And would it have made a difference? I'm not sure, but Donald West does corroborate the fact that no one other than Mr. Rose claimed ownership and had ownership of those packages. I would like to move briefly on to sentencing, if I may. The government is correct. The court did address the 3553A factors, but our position on that is there could have been improper consideration given to improper factors, which triggers the substantial reasonableness analysis. I could not read the emotions out of a transcript, but I can tell, and anyone can tell that has reviewed the record, that there was a contentious relationship between the judge and Mr. Rose because of Mr. Rose's behavior, arguably, that he was threatened to be removed from the courtroom on numerous occasions. He was chastised, and the trial court clearly said just prior to sentencing that he would certainly reap the consequences of his choosing to attempt to obstruct justice in connection with his motion to suppress and his trial, and was aware of a complaint that Mr. Rose had filed against him. So the argument being that particular situation in and of itself injected an element of unfairness and potential impartiality. And he did receive a sentence that was less than requested by the government, but it was more than requested by his counsel. And our argument would be that he did have a right to be sentenced by a fair and impartial trial court. And those comments call that into question. With regard to his leadership role as well, the court did focus on, he looked at the factors, the 7-factor test, but the focus was on the degree and control and authority over Mr. West. And Mr. West was not charged. Mr. West was paid a nominal amount for his role. The DEA agent even considered Mr. Rose to be a middleman. I believe it was Giovanni who said that. Rasul Lewis was considered the head of the enterprise, and they even utilized Mr. Rose in an effort to assist in their investigation of him. Also, Vinchon Hill, who was a local drug trafficker. There was no evidence that Mr. Rose had any ties to the Mexican cartel directly, and the sales and the Slade cases that I've cited in my brief do support rejection of the enhancement, because just because you sell cocaine or even have someone else sell it for you, that doesn't necessarily make you a manager or a supervisor. So I will be happy to answer any other questions the court have and reserve the remainder of my time for rebuttal.
All right. Mr. Almond, thank you so much.
Sir. Thank you.
Thank you, Your Honor, and may it please the court. The conviction and the sentence in this case should be affirmed. First, regarding the suppression motion, the district court correctly concluded that the defendant did not have standing to challenge the search of the two packages that were found to contain several kilograms of cocaine. Defendants have standing to challenge a search if they show, and it is their burden by a preponderance, that at the time of the search, that the defendant had a subjective expectation of privacy, and that the expectation is one that society is prepared to recognize as legitimate. Courts consider factors like whether the defendant owned the property searched, whether the defendant had a right to exclude others from the property, and whether the defendant took steps to maintain privacy in the property searched. Now, in the context of a search of a package that is in transit, courts have regularly concluded that the sender and the designated recipient have an expectation of privacy in the package, and that is the Jacobson case in the Supreme Court and also the Hurley case, not the intended eventual recipient. In the Givens case, that was a Fourth Circuit case in 1984, this court concluded that if all intended eventual recipients had an expectation of privacy, then that would create a rule with no end. Then all subsequent potential recipients of drugs, for example, would have an expectation of privacy in a drug shipment. And in this case, the district court properly concluded that when the packages were searched at the FedEx facility, the defendant had no expectation of privacy in the packages. And at the suppression hearing,
That's a seems to be a legal conclusion. It's not a factual finding so much as because who did own the package when it was sent, when it was searched?
and Your Honor, yes, the court did make a series of factual findings.
It's your question.
Yes.
Who owned the package when the first package was searched? Who was the owner?
At the time that it was searched, according to the case law, there were two different.
I'm not talking about case law. Case law. I'm asking this a simple question. Who owned it? That's just plain property law. That's property law. From first year law school type stuff. Who owned it?
Your Honor, I don't know the answer as a property law matter. I know that both the recipient who's listed on the label and also the sender are the two individuals at that moment who had a right and expectation of privacy in the package at that moment. As a matter of property law, I do not know who would be considered the owner, but I do know that the case law has been clear that
You think the recipient is an owner, correct? If you buy something from a place, Acme, whatever, and you paid your money for it, and you said, and they're going to ship it to you, you're telling me that you're not the owner?
in a case where, for example, someone else sent me something and I did not pay for it and I did not know it was coming to me, I'm not sure as a matter of property law whether I would be the owner or not, but I would have an expectation of privacy at that moment.
But wait a minute, if I tell you, for example, somebody, pornographic material, totally legal, not obscene, it's pornographic, and it's an adult material. And I say, well, I don't want people to know that I'm, getting this, so send it to Joe Willie. You mean I don't have an expectation to get that package, get my pornographic material?
Your Honor, the case law is clear that if the package is being sent to an address that you have a connection to, or if you have, for example, a phone number on the package that is associated with you, or if it is sent to a fictitious name, but that is one that has been established as one that you've used publicly, those are all factors that would be considered, and you could still have an expectation of privacy.
That has nothing to do with it in terms of, you mean to tell me I can't send it to my next door neighbor and put it in their name and I tell them, listen, when you get this package, this is my package and don't open it. It's mine. I don't have an expectation. I lose that because I give it to I have it sent to my neighbor's house and I have an agreement? Because that's what you're arguing?
Your Honor, that is what this court held in Givens, which was 733 Federal 2nd 339. That's the 1984 case. In that case, the package was sent to Debbie Starks, who was a co-conspirator of Debbie and Gary Givens. And that was a real person, Ms. Starks. And this court found that the defendants, Debbie and Gary Givens, were the intended eventual recipients of the package, but they were not the designated recipients of the package at the time it was searched. And so this court concluded that those intended eventual recipients, the defendants, did not have standing to challenge the search of the package at that time. And there's a good reason for that. Those defendants were attempting to disassociate themselves from the package, and without any kinds of indicia that they were the individuals who could go to, for example, the FedEx facility and show, in this case, and show that they were the rightful owners or the designated recipients of the package, then at the time of the search, they did not have an expectation of privacy that would have been recognized as legitimate, according to the Fourth Circuit in this case.
In a Frank's and a Katz analysis of expectation of privacy, it really makes no sense.
Well, Your Honor, as Your Honor knows, under Katz, there are, and the subsequent case law, there really are two questions: whether there is a subjective expectation of privacy, and the defendant may have expected that his package would have remained private. But then the second one is whether that expectation is objectively reasonable and one that society is willing to recognize as legitimate. And this court and other courts have repeatedly—
You can't define it by that it's illegal, then you would never have, that's a tautology. Well, there's no expectation because what you were doing was illegal. Then you would never have suppression. That's the whole idea. You want to suppress stuff because it is contraband. That would turn logical and say, hey, let me finish. So the question is, in normal sense, what a reasonable person would think. You mean to tell me that if I send a package and I tell my neighbor, I'm putting it in your name, but it's for me, I'm establishing my ownership and expectation right there. And that's what this record is. Did Mr. West receive these packages only as a benefit of Mr. Rose? Yes? You can say yes.
Yes, Your Honor. He did absolutely.
So he always, and he made sure under this record that it would be for me. You don't lose expectation because you send it to an address where you don't live. That means that a homeless person would never have an expectation of privacy in anything because they don't have a home. So they'd have to say, well, listen, can you, as a good Samaritan, would you please accept this because I'm homeless? And you would say, oh, well, you can't have expectation of privacy because you don't have a home. That wouldn't make any sense. In the cases you're citing, those are people where they've made a step back. That's not mine. I don't know whose that is. In this case, Mr. Rose readily said, that's my package. It's mine. It always has been mine from the transit all the way through. And the evidence here, you can see the police officer, they got smarter, but perhaps too late. In the second package, oh, we better get a warrant. But the fruits of the poisonous tree attached perhaps already. Because if they felt the same way, they open them all. Everyone that's from Arizona that's taped like this one, open them all, because nobody has an expectation of privacy, or because it's not the person's name on it. And whether it's fictitious or not has nothing to do with expectation of privacy, or whether I've established it before either. As long as I'm controlling it by saying, that's my package, it's coming to your house, it's mine, and it was understood. As a matter of fact, he paid for it, didn't he? It wasn't even just it was a contractual agreement. Even more so that he owned it because he had made that, in a sense, his resident for contract, didn't he? Is that true? He said, listen, I'm gonna give you this amount of money if you allow me to use this address when it comes, and I'll pick it up. Aren't those the facts?
I believe that at trial, he clarified that he was paying Mr. Donald West in crack cocaine as opposed to money. But yes, he was giving him a benefit for receiving the packages.
But because it's illegal, you can't use that. That defeat expectation of privacy because it's legal. You agree with that, don't you?
And Your Honor, I'm not making that argument. I'm not making the argument that the type of contraband matters at all, because obviously for any type of suppression issue, you ignore the knowledge of what is inside the box. I'm not suggesting that at all. But I do think this case is very similar to, example, the Hurley case, which is a Fourth Circuit case from 2006. There, the package was addressed to a Brian Painland from a Miguel Espinoza. There, the defendant directed the shipment. He had never used that alias. The phone number on the package was not his. The defendant did not reside at the address where it was being sent. And this court held that the defendant did not have standing. And this court said,
in that case, what was the connection at all to the delivery of the package to that address? That's the key. What was the connection, asserted connection of the package to the address? Here we know what it is. It's coming. It's in a different name, but it's mine, and you directed only to me. In your case, what was the connection? There was none. So when
Your Honor,
well, go ahead. Tell me what the connection was to that delivery, to that place, in the case you just cited.
Your Honor, I don't believe there was evidence in the record in that case. And what
it wasn't. That's why you cite that then. It's an opposite factually for this case.
Your Honor, and what the court concluded in Hurley was that it was analogous to a package being sent to a third party. And so in the Hurley case, again, this court reiterated that when a package is being sent to a third party that is not the defendant, and the defendant can't show a connection to the address or the use of a fictitious name or a phone number or an invoice, as it was used in the Villarreal case, and there the defendant did have an invoice.
That's because the third party has no connection with the person. Here you have a direct relationship. It is a money relationship. He says, listen, I will pay you to be my surrogate address for this package, and when it comes, you don't even supposed to look in it or touch it. It's mine. That is the undisputed fact in this case. And we don't have to rely on the district court for making a legal conclusion of these facts. That's wrong. That's really not a factual determination at all. Matter of fact, it almost belies the facts in this case, because it's cases that really factually are different. But go ahead tell me.
And Your Honor, in the Givens case, that was the Fourth Circuit 1984 case. In that case, the package was being shipped to a co-conspirator of the defendants. And so there was a relationship between those individuals. Debbie Starks, who was listed as the recipient of the drug package in the Givens case, was determined to be a co-conspirator of Debbie and Gary Givens, who were the defendants. And again, this court rejected the argument that the defendants had standing because they were unable to show, and it was their burden, they had to show by a preponderance, that they, at the time of the search, had standing because they had an expectation of privacy in the package. Yes, Judge Kinnear.
Mr. Lemon, does the record show, if I'm correct, the record shows that one package was delivered like a month earlier? Is that correct?
I believe there was testimony that there had been two packages delivered prior to these two.
Okay, and did they both have the name Ronald West on them?
I believe that was the testimony. I don't think that labels were introduced, but yes.
Does that make a difference? I mean, because it would suggest, it seems to me, that there was an established use of the name Ronald West before the incidences that we have in front of us.
Your Honor, I would suggest that this was a strategic use of the name of a deceased person to disassociate the defendant from these packages. So there was testimony that, and I believe this was, I can't remember if this was in the trial when Donald West eventually testified, but there was testimony that at first the defendant wanted to use Donald West's name on the package. He didn't want his name to be used, and so Ronald West was actually used. There is no evidence introduced that the defendant ever used the name Ronald West publicly. In fact, there was evidence given at the suppression hearing that he used the name Boo Boo. That was what Donald West told officers on the day of the arrest. And
okay, how much time elapsed between the first use of Ronald West and the packages that we're talking about?
I believe it was all within just a few months. I don't have the timeline right in front of me, but I think it was between maybe 3 or 4 months apart that these packages were sent.
Well, would it make a difference in this case if he had used Ronald West continuously for a year? You see, what I'm getting at is you have facts of a prior use of Ronald West. So what's the cutoff here in the expectation of privacy analysis? Are you saying that even if he had used the name Ronald West on packages for a year, there would be no expectation of privacy?
Your Honor, it is a totality of the circumstances type of analysis. And I think that all of the cases where we have seen this court conclude that a fictitious name or an alias was something that a defendant could rely on, it was in a situation where they were using that name publicly.
Okay, but I'm asking you the hypothetical question.
Sure.
If the defendant had used the name Ronald West and had a series of packages, let's say 25, in the name of Ronald West delivered to the residence of Donald West over the course of a year, would your analysis be different?
I would still argue, Your Honor, that that is more akin to using the name of a third party to disassociate a person from a package, as opposed to using a fictitious name, for example, in the Villarreal case, where a person is using a name that they are known by outside of the package context. I think that using the name Ronald West, who was a real, although deceased person, was more like the Givens case where the name Debbie Starks was used, and that's more like a third party being used as opposed to a fictitious name. And in this case, the defendant had a different nickname, which was Boo Boo, and he did not provide any evidence to the court, and it was his burden to show that he had used the name Ronald West in any context other than in this use, which is his name on the packages, using Ronald West's name on the package.
I just don't understand it. It's not illegal for me to use a different name, right? I can ship.
Correct.
I can ship anything I want. I mean, anything you want, but I could ship legal things under any name I want, unless I'm using somebody's credit card and using their money. But I don't have to be, Roger Gregory. I said, okay, I'm somebody else today, but I paid for it and I wanted to deliver it to somebody else's house. How does that? I just can't see how you can say you lose the expectation of privacy because I don't use my name.
And Your Honor, I agree that it would not be illegal at all to use someone else's name. The question is more whether it is an expectation of privacy that courts and society have recognized as legitimate. And there have not been cases that have been cited by the defendant like this one. I think that if the defendant had been able to show that he had an invoice connected to the package, if his phone number had been on the package, if he had shown that he had used the name Ronald West publicly, I think if he had any connection, for example, staying overnight regularly at the location at Donald West's house where the package was being sent, all of those would have been factors to show that at the time of the search, he at that time had a right to exclude others and had not given that up by trying to dissociate himself from the package.
I don't understand. So that means that if I send the package and I thought it was gonna get there in 5 days, whatever, but it didn't, and I went off to Paris somewhere, that means it's not an expectation of privacy. I mean, what made it different? You're talking about if he had gone there and showed it with an invoice. You don't need an invoice. The idea is you've already paid for it. All you want the shipper to do is ship it to an address. And in the facts here, didn't he show up almost immediately and pick it up?
He did, Your Honor.
Is that consistent with ownership?
It may be consistent with ownership.
No. Is it consistent with ownership when the package shows up, you come almost immediately and pick it up? Is that consistent with ownership?
At the time it was delivered, potentially, but not at the time of the search.
But at the time of the search, you don't know where the package may go. My goodness, the past holiday, then the indication a package takes a long time to get, maybe sometime a while to get there. So you mean to tell me that, oh, my expectation won't attach until it's delivered? That can't be the law.
Your Honor, if you were able to show that you had, for example, a phone number that was associated with the label on the package, if you had an invoice, if you had documentation showing you had shipped the package, for example, a tracking number, a receipt that you might have gotten when it was dropped off at USPS or the FedEx facility, those are all indicia of ownership and an ability to exclude others.
I agree they are, but they're really not required at all because that's not the core of an expectation. I mean, many times people take receipts and ball them up and throw them away. And you mean to tell me because you threw the receipt away, you've now lost your expectation of privacy? That can't be. That's a, you know, that's a, well, anyway, I just don't see how you could have any logic to that in terms of any sense of expectation of privacy. Oh, I'm sorry, sir, ma'am. You don't have a receipt or invoice, therefore you have no, this is not yours. This is gonna go to the lost and found.
If you were still the designated recipient, if you were the listed sender or the listed recipient, or your address was the listed recipient portion of the label, then you would absolutely still have an expectation of privacy.
Well, did it require a signature for this package?
I don't believe so, Your Honor.
It did not. Absolutely. All it did was to drop it off at an address. This is a red herring to throw in this invoice and receipt and all those things. I guess you'd say it'd help too if you could show the check, the cancel check that you paid for with, or the piggy bank that you got the funds from. Yeah, that'd be nice, but it's not required for expectation of privacy. I mean, my goodness, we turned logic and in the sense, I mean, the framers were pretty smart people. I mean, some of these things with the case law has crept in terms, they wouldn't even recognize Fourth Amendment protection in many ways. Oh, well, you can go in the box anything you want because, you know, why is it, you know, we don't know what they would do. I mean, you're basically saying because this is a bad purpose, then it can't. But we have to look at the average citizen, the non-criminal conduct and see it in commerce. And I don't see any case that says here that you can't, that filing something or sending something in somebody else's name, when you pick it up immediately, you tell the person who owns the property, it's coming, it's mine, and they agree to it. That's expectation on steroids.
Your Honor, I see my time has expired.
I know you're ready to go. My colleagues, you have any questions of Mr. Lemon?
No, thanks.
I do not.
Thank you, Your Honors.
Mr. Allman, you have some time left.
Thank you, Your Honor. May it please the court, just to I guess, correct to some extent what was represented as being on the record. It was clear from Mr. West's testimony that he was sometimes paid in crack cocaine, but he was also sometimes paid in funds and monies. And that indicates that it happened more than twice. It happened several times that this delivery was made apparently under the same name to certainly the same address. So there was a pattern in practice, as I indicated earlier, of the use of this particular Ronald West name and to that particular address. With respect to the cases that the government has argued, the Hurley case, once again, we have a situation where the defendant did not know the person who resided at the delivery address, much less have used that same address on previous occasions. In the Givens case, that was an actual person, a real person, a co-defendant that the package was sent to. And yes, they were attempting to disassociate themselves from the package, as opposed to Mr. Rose, who never tried to disassociate himself from the package, but claimed the package as his own. He placed the order, he arranged for the delivery, he picked the packages up within a short time of their arrival. He claimed ownership. The law enforcement officers all recognized that those packages belonged to him, no one other than him. And he went to jail for it. And I would suggest, I heard this in law school many times, many years ago, that sometimes hard cases make bad law. Yes, this was, narcotics were found, but the purpose of the Fourth Amendment is to protect people in their rights of privacy, their persons, their places, their effects. This was his package. There's no question it was his package. It was his package when it was shipped. It was his package when it was searched. It was his package when he came and picked it up, and he's serving time because of it. And the bigger picture, I think, is more important in this case, to send a message that a person does have an expectation of privacy in a package. Akin, as Your Honor has suggested, Judge Gregory, that if it were sent to a neighbor under the neighbor's name or a different name, in my example would be to ensure delivery. That would still be my package. And I think that's an important, very important aspect of our Constitution that I hope this court will protect. That's all I have, unless there are questions.
Thank you, Mr. Allman. Appreciate it.
Thank you.
Thank you so much for your arguments, both of you. Outstanding job. And we wish we could come down and shake your hand. We can't, but know that we appreciate very much your being here and your arguments. Thank you so much. Be safe and stay well.
Thank you, Your Honors.
Thank you, Your Honors.
Thank you. My dear colleague, want to proceed to our last case.
I'm fine, however you all want.
Yeah, I'm fine as well. If anyone needs a break, I can do that, but I'm good.
Oh, no, I always ask because I normally push right through. That's why I make sure I ask for my colleagues. All right.
Oh, thanks for asking.
All right, we'll proceed to our last case for the day. Brian?
Byrne.
Byrne.
Your Honor.
Byrne?
Yes, sir.
You may proceed.
Thank you, Your Honor. May it please the court. My name is Jonathan Byrne. I'm appearing this morning on behalf of Ryan Kibble, who is the defendant below. Mr. Kibble suffers from a congenital heart defect as well as recent onset non-alcohol related cirrhosis of the liver. He's also incarcerated in the middle of a global pandemic. The district court correctly concluded that those are compelling and extraordinary reasons that could justify Mr. Kibble's compassionate release. However, the district court was incorrect in concluding that Mr. Kibble's release would pose a danger to the community or would be inconsistent with the sentencing factors laid out in 18 U.S.C. 3553A. The district court ultimately abused its discretion by denying Mr. Kibble's motion for compassionate release, and we'd ask this court to reverse that decision and order Mr. Kibble's release as soon as practical. The district court's decision to deny Mr. Kibble release came down to two separate provisions. The first was the district court's conclusion that Mr. Kibble would be a danger to the public if he was released. That is not supported by the record in this case, which shows that not only would Mr. Kibble, when he is released, be on a supervised release and would be released to a stable home environment, but that Mr. Kibble was on bond for 9 months after his arrest, prior to his sentencing. And even after his sentencing, the district court determined that it was appropriate to let Mr. Kibble self-report, and in doing so concluded that he was not a flight risk or a danger to any other person in the community. He spent another month on bond before he reported. Yes, Your Honor.
Mr. Byrne, could you also give us an update on Mr. Kibble's medical condition as it relates to COVID?
Your Honor, what I'm aware of with regards to that, he did test positive at one point in this litigation, but as far as I'm aware, he did not develop any symptoms. So I'm not sure if that was a flawed test or if he dodged a bullet. He, as of last week, is my understanding that he has not been vaccinated yet, and it's my understanding that while there is a plan within the Bureau of Prisons to provide vaccinations to inmates, it's kind of hit or miss at this point, like it is out in the rest of the world. And the current situation at FCI Elkton, which is where he is still incarcerated, is that there are 5 inmates and 30 staff members who are currently affected with COVID. There have been 9 deaths at that institution.
You're saying 9 deaths from COVID?
From COVID, yes, Your Honor.
Okay. Thank you.
You're welcome. As I said, Mr. Kibble would be on supervised release for a term of 15 years, where he'd be granted compassionate release. He has numerous special conditions that have been imposed, including a requirement of mental health treatment, requirement that he undergo a sex offender evaluation and participate in any recommended treatment based upon that evaluation. There are conditions that keep him from being around minors, from using computers, and other things that would protect the public from any misbehavior.
Argument here. I certainly understand the merits and the substance of the arguments made below and the appeal. Considered them and determined that the factors, including those under 3553A, find extraordinarily and compelling circumstances. So here's my question. Under your argument, if we have a COVID outbreak at a prison, does a district court have discretion to deny a compassionate relief motion? Or are you saying that the existence of the pandemic effectively takes away that discretion? It feels like that's almost what you're saying.
No, Your Honor, that's not our position. Our position is entirely related to the particularities of Mr. Kibble's situation.
So if you have, I'm sorry to follow up. I hope I'll give you time to answer. So I'm sorry to cut you off as you start, but anticipating that. So let me take my question a little bit further. If you, if you're a prisoner with COVID with the types of underlying conditions that make you have a heightened risk or a certain level of risk, at that point, does the district court not have discretion?
No, Your Honor. I think the district court always has discretion based on the equities of any particular case. I could conceive of a situation where you have someone with a condition similar to Mr. Kibble, but who was serving a life sentence, perhaps for a homicide. And in that case, the question of release is a much different question, because Mr. Kibble is going to be released at some point. It's a question of when. Okay. And our position is both his medical condition, but also the facts of his case should have led the district court to the opposite conclusion.
Let me ask one other question, and I think that I appreciate your answer. The government in its brief, I think, said something to the effect that if we were to order relief, that it be temporary. Do you believe we have the authority to grant compassionate release for a certain period of time and then order, or does a district court have this authority to grant relief for a certain period of time and then order the return to prison for the remaining of the sentence?
I am not aware of any courts that have decided that issue, Your Honor.
What's your position about it?
Our position would be that the district court would not have that authority. That's once the release is done, because you're going to have a situation where Mr. Kibble would be on supervised release, and if he had problems on release or violated, he could be revoked for that. But if he is released and 6 months or a year goes by, who knows how long this is going to continue, and he's performing well on supervised release, it shows that the sentence that he actually served was the appropriate sentence. So
how can that be if the primary basis is really not a challenge to the underlying sentence? It doesn't seem to me. It seems like what you're talking about is the presence of the COVID pandemic and his risk to it, and putting aside whether he got it and is recovered or what, even if none of that was true, wouldn't if the COVID situation, you're right, I have no how long, we don't know how long it's going to be there, but if hypothetically in 6 months, everyone's vaccinated, it's not rampant at Elkin, it's not completely gone, but it's nowhere near the risk that you would posit it is now. Why would there be a restriction to allowing release for a period of time to end and then be returned?
I think largely it would be a question of the equitable aspects of it, in that you would have a person who would be released to the community and would be reintegrating into the community, who would then be, through no necessary fault of their own, like in a supervised release revocation, be put back in prison. And I don't think the 3553A factors would support that, because if you look at the district court's original explanation of its sentence, which is at page, I believe it's 152 of the joint appendix, the only factor he really specifically mentioned, aside from the offense itself, was the need for deterrence. Well, the record kind of supports the idea that Mr. Kibble has been deterred. He was out in the community for nearly a year without any issues. If he were released and was again out in the community for 6 months, a year without any issues, then the main concern of the district court, which was the need to deter this conduct, would be addressed. And so I don't think that is a situation where the district court would have that authority. Yes, Your Honor.
Okay, but Mr. Kibble, if you look at Joint Appendix 366, the district court did make a factual finding regarding the defendant's dangerousness, saying the court cannot ignore the dangerous nature of defendant's conduct, nor is it assured that the defendant would not present a danger to other minors if released from prison. So that seems to me to be a fact-specific finding relating to his likelihood of being a danger to others that was the basis for the court's exercise of its discretion not to release him. So how, you haven't addressed the fact that the district court seems to think he would or might well be a danger to other minors if released from prison.
Yes, Your Honor. We think that conclusion is incorrect and not supported by the record, because this is a case where we have, again, this basically 10 months of good conduct under supervision, which is the kind of supervision Mr. Kibble will have for the next 15 years. And we also have the other finding of the district court at sentencing that he was not a danger to the community. So there's a conflict there. And I think that finding is more supported by the record than the district court's finding in the denial of the compassionate release motion.
I guess though, you have a situation here when the district court ruled Mr. Byrne had only served 10% of his sentence. Now he's served about 20%.
About a quarter, yes, Your Honor.
The district court was making the factual finding in terms of the compassionate release in a different factual context. The district court may have said that he's not a danger to the community once he serves a long sentence, but he's barely gotten started here, and I can't say he won't be a danger to others if released.
If that's the case, it would have been an unusual decision to leave him out on bond to self-report for a month if he was a danger. Alternately, it's a suggestion that what makes him dangerous is his term of imprisonment, in which case that further mitigates against or towards cutting it short as soon as we could.
No, in other words, he hadn't served enough of his time to make an impression on him that this is not conduct that society finds acceptable.
Well, I think the record as it exists now shows that Mr. Kibble has come to that conclusion, and it's bolstered now by almost a year's worth of imprisonment. And it's not only a year's worth of imprisonment in a regular world, but in a COVID world. I know I keep coming back to that, but it's hard to avoid. Time in prison during the pandemic has been harder than regular time. Facilities have been locked down. There's been no visitation for places. Programming has been cut back. And so Mr. Kibble has been subject to that for nearly a year. In addition, as I mentioned, he'll have this 15-year term of supervised release. When he's released, he'll have to register as a sex offender. He has, obviously, he's lost employment. His life has pretty much been completely upended by this, and it seems like the message got through to him, because in all that time on bond, there's no evidence that he was surreptitiously going back on the internet, that he was hanging out places where minors were present or anything like that. The record suggests that the message has been not just sent but received from Mr. Kibble.
Mr. Byrne, may I follow up on your response to Judge Quattlebaum about whether or not you could sort of call out, does the district court have the authority to call out or fashion a remedy, having found the extraordinary circumstances health-wise and the danger of COVID? In this case, he found it as a matter of fact. It existed. So he has to balance the other things. But you seem to suggest that it's an all or nothing. Why couldn't he say, well, the danger here exists now that COVID obviously is rampant, and we don't know vaccination. You got morbidity rate is high where he is now, and say that he will remain until, for example, if we get to a phase that's considered to be as close to what we call normal from a scientific public health standpoint. Until that time, he's on house arrest with restrictions, and then after which he will return to his someplace in the Bureau of Prisons for confinement. You seem to eschew that completely. Why is that?
Well, I see my time's up. If I can go ahead and answer that question.
Yeah, you can.
I don't want to preclude the court doing that if that is the best result that we can hope for. I simply think that a situation.
That's part of my wasn't asking you to give up on your main point, the all
Sure.
way. He was just asking you, do you, and that was the question was, the authority to do it. Obviously, we know you don't want that, but the question was authority. He didn't ask you to give up your main. And now go ahead.
Well, when it comes to the question of authority, like I said, I am not aware of any court that has exercised or held that district courts have that authority. And it's not evident from the plain language of the statute.
And that's because it's discretion and it's trying to deal with the situation right now. It could be other extraordinary circumstances, but right now it's COVID, and he found that it existed. That's not too much, that's not that avant-garde or abstract, is it? You're dealing with a temporal, we hope and pray is temporal, in short, in that situation we're in, and we're trying to address that. When that's over, don't you go back and serve your time that you have to until someone says, you're ready for some kind of parole for other circumstances or release, like your age or whatever. But why wouldn't that be in the wheelhouse of a remedy under this statute?
I'm just not certain, Your Honor, that without it being specifically laid out in the statute, that it's an authority the district court would have. I'm not certain that it is not, but I'm unaware, particularly because generally the law is a sentence once imposed is final, and the district court only has the authority to go back and do it to the extent the statute otherwise, or another statute says you can.
And what do you say that the statute says they can do?
Order compassionate release. And in my conception, release is release, is a termination of your sentence.
You putting that on it, it just says release. It could be released for a period of time. You're putting on it that you're adding something to it. There was a reason why it said release, because don't you think in terms of statutory construction would be release for 2 months, release for a year, 2 years, or release, as you suggest, for the entire sentence, active incarceration? Do you agree with that in terms of statutory interpretation?
Yeah, I agree that it could mean that. I'm not certain that that is what Congress intended.
But I'm sorry, go ahead, Chief.
No, go ahead, I'm finished, go ahead.
No, just to follow up then, I mean, isn't almost the corollary of saying that authority doesn't exist pretty kind of akin to saying a temporary situation like we have here is not contemplated by the compassionate release statute? I mean, I think that's quite frankly, I think that's a fairly dangerous position to advocate, and almost undermines whether COVID could be even the basis for it.
I don't think so, Your Honor, because I think what the court can consider in terms of the basis for compassionate release are fairly broad, as some recent decisions of this court have held. But I'm not sure that necessarily plays into what the potential relief is.
Okay.
All right.
Thank you.
Byrne. Ms. Harold?
Thank you, Your Honor. May it please the court. The district court did not abuse its discretion in denying compassionate release for this defendant. The basis of this denial was the Section 3553A factors, which the First Step Act specifically calls out as something that must be considered in addition to those extraordinary and compelling circumstances to determine if release is appropriate. The court's bases were the egregious nature of the offense, which had just been articulated by the court at the sentencing a few months prior, the minimal portion of the sentence that the defendant had served, and importantly, not so much the need for specific deterrence of Mr. Kibble, but the importance of general deterrence. And that's also laid out in his order with regard to the length of this sentence. The district court had a very valid concern that a roughly 90% reduction in his sentence at the time that he denied this would undermine just punishment. It would undermine the reflection of the seriousness of the offense. It would undermine the general deterrence that he was so concerned with at the initial sentencing only a few months prior, and it could create unwarranted sentencing disparities. And the court reasonably took into account the fact that this particular defendant had already tested positive for COVID, given that the entire argument for compassionate release is to avoid exposure to COVID in a prison situation when you have the kind of high-risk factors that the defendant does have. That is substantially reduced as a concern when they have already contracted it. And to this day, the understanding is that reinfection is fairly unlikely. And we're also at a point where vaccines are rolling out in the BOP. Another factor you look at is the nature of the risk in that particular facility. And as Mr. Byrne pointed out, Elkton currently has only 5 inmates that have active cases. So obviously they have really brought into control the outbreak at that facility.
How many people at that facility? How many people? How about? Do you know?
I believe there's about 1,100. It could be a little more. I might be thinking that there's 1,100 sex offenders there. I remember looking at these statistics, and I apologize that I did not look that up. But it is over 1,000 individuals. Perhaps Mr. Byrne can correct me on those details when he comes back to rebut this. But it is a large number of individuals at that facility, and only 5 of them are currently active with infections of COVID. It seems that staff is actually much more at risk in that facility right now than the inmates themselves.
I mean, you must, I would assume, you admit, counsel, that in terms of science, we don't know what it means having been exposed, not exposed, but to test positive for COVID has to do in terms of connection of being reinfected. We don't know that, right?
That is true, Your Honor.
We don't know. So the fact is he's had it before, we can't say it lowers the chance that he won't get it again. We don't know that.
That is true.
Obviously, we could conclude that it shows that he's susceptible to it more than other people and more likely than someone who, right? You could argue both sides of that in terms of the science.
Well, as far as the science, I don't know that any one person contracting it means that they have a predisposition to contract it. But also along those lines, we could also argue that he apparently has a predisposition to be able to fight it off with his own body because he contracted it and never had any symptoms. So that could also be an argument that he seems to have a natural immunity that other people do not have despite his medical conditions. But again, even with these issues, those are up for debate. But what the court based it on, the court didn't argue that he was not, did not have this extraordinary and compelling circumstances based on the conditions of the prison and his medical condition. The court based its ruling on the 3553A factors. And primarily, while it did offhandedly reference his positive case, its primary concern was the general deterrence effect and the nature of the offense and his concerns about this individual's release into the community.
Well, you must admit, I think you would admit that Mr. Burns' point is assuming, or not assuming, as stated, dangerousness was a concern on the 3553 factors. But you have to, I was saying, concede that it is a little inconsistent with his pre-trial release, right? Post-conviction release and post-sentencing voluntary reporting, isn't it?
Your Honor, just to I don't think they are they are inconsistent with each other necessarily, and particularly to the point that the other 3553 factors would be overridden. But just to point out the specifics with regard to his release following his plea hearing. In the record, and it's at JA 44 through 46, it was discussed that typically this offense would require remand following that plea. But a couple factors, and it was specifically discussed. One, this was an 11C1C plea, and the court did not adjudge him guilty at the plea hearing because he wanted to review the PSR and determine whether he was going to accept that binding plea agreement. But further, when he asked for the United States position, the United States had spoken with defense counsel, and Mr. Kibble was scheduled to have a surgery in the time between the plea hearing and the sentencing. And that surgery would have been unable to be completed had he been remanded to the regional jail during the time between his plea and his sentencing. So because of that, the United States opted to find that that was a circumstance that would warrant his release on the restrictive electronic monitoring conditions that he was under at the time. And given the short period of time for self-report, I think the court at sentencing simply said, you've been on this for a long time. I'm going to give you this additional month before you report.
That covers one leg on the three-legged stool. What about post-conviction?
That is post-conviction, Your Honor. I think he looked at it as, I'm giving you a very firm report date that is a month out, and essentially continued this bond.
Post-conviction? How long was he out post-conviction?
Well,
conviction and the sentencing.
Oh, conviction and sentencing, that's what I was just addressing, Your Honor. He was not actually adjudged guilty until his sentencing. The court did not make an adjudication at his plea hearing. It withheld that, held it in abeyance until the sentencing. And the time period between when he was adjudged guilty at the sentencing hearing and his self-report was 30 days. And again, that time period between the plea hearing and the sentencing is when he had that surgery. And that surgery was what was considered the specific reason that he was allowed to remain on that bond. So I think that those specific circumstances undercut an argument that he can't be found dangerous now because he was allowed to remain on electronic home confinement during the pendency of his case, following a month of detention in the early portions of his release, or in the early portions of his case.
Well, for 9 months, he was allowed to be out, correct?
Yes, Your Honor. But again, dangerousness is also only one of Section 3553A factors. And while the court did make this finding in its order that he was a danger, it also specifically said, regardless of whether I found him a danger or not, I still believe that the 3553A factors alone warrant the denial of this motion. And the discretion that—
Which one's beyond dangerousness? What's the other ones? What other ones did he mention?
As far as 3553A, Your Honor?
Yeah.
With 3553A, he focused on the nature and circumstance of the offense, the egregious conduct that was engaged in. And again, he referenced the general deterrence, which general deterrence was his primary driving factor at the original sentencing. He specifically had stated at sentencing that this case cried out for a sentence at the top end of the guidelines to allow for maximum deterrent effect. And in that context, he was speaking about general deterrence, not specific deterrence for Mr. Kibble. But the court also looked to the fact that he had only served 10% of his sentence, that to release him now under 3553A would undermine the importance of just punishment. It would undermine a reflection of the seriousness of the offense, and it would additionally create unwarranted sentencing disparities between individuals who had engaged in similar conduct and who were serving many years. For the defendant to get out after serving only a few months, the court felt would create those unwarranted disparities under Section 3553A. And these are all reasonable bases for this conclusion. And the standard here is abuse of discretion. And essentially, Mr. Byrne is arguing that once you have found that there is COVID in your prison, and once you've established that there are these medical necessities to get the compelling circumstances, that trumps the remaining 3553 factors. And that's simply not the case. If that was the case, the First Step Act would not have included a requirement to consider 3553A. And the court is well within its discretion, having known the record, having met the defendant, having participated in this case, to find that the other 3553A factors outweigh the danger. There's nothing in the record to suggest that the court did not find that there was a concern about COVID at FCI Elkton. And there was never a question whether the defendant had these qualifying medical conditions. So the court did not inappropriately ignore those. It simply found, based on the reasons it's articulated, that those factors were outweighed by other reasonable 3553A factors. And the fact that others may disagree in the balance, which is what is argued by defendant, does not render the court's decision an abuse of its discretion. And if there are no further questions, the United States would simply find that since there cannot be shown an abuse of discretion, and the court did not abuse its discretion, its order denying the motion for compassionate release must be affirmed.
Counsel, you do agree that in terms of looking at this in terms of giving some jurisprudential guidelines, that notwithstanding, the court can use their discretion in terms of looking at 3553A factors. Sometimes it could be too heavily focused on one factor and make it unreasonable, correct?
It could, Your Honor. The United States position, however, is that a focus, which is what is asserted by the defendant, on solely the danger in the prison and the medical conditions, that would be too far weighing on only one. The judge looked at literally all of the other factors. He named 4 or 5 additional factors beyond that situation at the prison and the defendant's medical circumstances as outweighing that. So this wasn't something where the judge relied on one factor and decided that one factor alone outweighed it. It looked at a number of different factors, and that is not an inappropriate single focus on one factor, ignoring all others.
For example, what I mean is this. I think you said is 10% of his time or so had been served, only 10% of the time. For example, you can't rely too much on that numerical factor, can you, when the statute, when it says that they shall have the right to be considered for this release on this basis. And here they did find the compelling medical situation. So, well, that would say per se rule. Okay, if you serve less than 50, you don't get it. You couldn't do that, could you?
No, Your Honor. This is a very individualized situation, and the United States is not arguing that there is a bright line rule of you have to serve this percentage. The court is correct. That's not articulated in the First Step Act. But in this particular circumstance, the court found that the offense itself, the conduct this defendant engaged in, the importance of general deterrence, the importance of reflecting the seriousness of the offense, simply could not be satisfied by serving only 10% of this sentence. The court felt at the sentencing hearing that a sentence at the top end of the guidelines was appropriate, given 3553A, and felt that those purposes would be so undermined by a 90% reduction in sentence in this particular case that it was not warranted.
I'm trying to find some guidelines, so I'm trying to get your wisdom here. What about, can the court look at Eighth Amendment factors? That is, that COVID, for example, is so rampant in the place of incarceration that it would be cruel and unusual punishment to keep a person in a place there with a morbidity rate that high in terms of, he wasn't sentenced to execution or life. So, for example, would that be appropriate? Look at Eighth Amendment concerns, a constitutional question under this First Step Act?
Your Honor, particularly in light of the recent decision in McCoy, courts are, when you look at the policy factors that could be interpreted, arguably the Eighth Amendment could be a factor in that. But obviously the Eighth Amendment itself has very high standards for what actually would constitute cruel and unusual punishment. So I think that there would be a heavy burden to establish that COVID alone in a prison situation constituted cruel and unusual punishment, particularly since COVID exists outside the prison facilities as well. I think this is a very unique circumstance. Obviously, the court, in establishing, looking to policy, could look to many different factors. So I don't think there's anything that necessarily would preclude looking to the Eighth Amendment, but I do not think that in most cases that would be something that would be reached on an individual basis as a reason to overshadow the 3553A factors if those factors weighed against release. Yes, Your Honor.
I have a question. I don't think this is part of this case, but as we kind of reflect on this issue that's new, is it appropriate in considering the COVID issue if that's going to be a factor in the prison, is it appropriate to look at the risk of COVID in the situation to which the defendant would be released?
I think that is a factor that is appropriate, Your Honor, to look to. In some situations, there have been cases where a prison facility that a particular defendant is in has very low rates, and they were requesting to be released to, say, a residential halfway house that had in and out traffic regularly in a community that had a high level of community spread, which arguably would be a greater risk than the prison itself. However, it's one of those factors that has to be viewed very cautiously, because just like the situation in the prison, the situation out of the prison is going to be very fluid, and a case that could be a residence that might at this point be safer could easily become more dangerous as the prison gets under control and that community has community spread. So especially given the temporary, hopefully, nature of this pandemic, that is a consideration I don't think the court would be prohibited from making, but I think it has to be taken with great caution.
All right. Anything further, counsel?
If there are no further questions, I would rest on my brief, Your Honor.
Thank you, Ms. Harris. Mr. Byrne, you have some time reserved.
Yes, Your Honor. And to begin, I'm happy to admit when I'm wrong, and I want to point the court on the issue of the district court's ability to do something other than order complete release. I want to point the court to United States versus Lagan, which is 18 CR 283, docket number 91. It's in the Northern District of New York, 2020. And in that case, the court held and has citations to other courts that have also held that the statute allows only for release, not a temporary placing back into the community that would then end when the extraordinary and compelling reason would be gone. So there has been a court that has decided that. I wasn't aware of that.
Now you're pointing to authority that supports your position.
Yes.
Okay.
Which I didn't know existed until 10 minutes ago. So on the issue of when the district court allowed Mr. Kibble to remain on bond pending his self-report, without taking issue with anything that Ms. Harold said, I would point the court to what the district court found. And this is at page 154 of the joint appendix. The court says, Mr. Kibble, you performed up to standards on bond. The problems were electronic and telephone problems that weren't your fault, as I understand, so I'm able to find that you have complied with your conditions of bond. I find that in view of that, you're not a flight risk or a danger to any other person or the community under the present circumstances. And so I would come back again to what has changed after this time, and it does not square with the record. To comment on something that Judge Quattlebaum brought up with my colleague, while there may be situations like Ms. Harold suggested where someone is requesting release to a halfway house, or maybe there was the Ramey case that was cited in the briefs where the person seeking relief was basically homeless, Mr. Kibble would be much better off in terms of COVID precautions, released at home, able to comply with social distancing guidelines, which could be incorporated as additional terms of supervised release if the district court felt it was necessary. Another thing about the COVID situation is I don't think we can assume that because Mr. Kibble got a positive test and didn't get sick that he is immune. And indeed, in the government's brief, they didn't take issue with the district court's conclusion of extraordinary and compelling circumstances. They relied on the 3553A factors. If there are not any other questions, I believe that's all I wanted to address on rebuttal. Thank you, Your Honors.
Thank you. Thank both counsel for your fine arguments, and we can't come down and shake your hand, but please know that we really appreciate your being here and helping the court and letting us pick your brain about the broader issues as well as your issues specific to this case. And we thank you so much, and I hope that pray that you'll be safe and stay well. With that, I'll ask the clerk to adjourn the court.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.
Judges, I will move you into the robing room.